My inaugural lecture focuses on green transition and the future of Africa's investment policy. Before exploring green transition, I need to first explain what it means. Green transition means progression towards climate-friendly practices in various aspects of in various economies and societies. However, it goes beyond climate change, and it focuses on environmental sustainability. The United Nations Intergovernmental Panel on Climate Change published a report in 2022, its sixth assessment report, where it found that Africa, more than any other continent, will be affected by the ravages of climate change due to three reasons. One, its size. Two, its limited capacity to adapt. And number three, its geographical location. My research has explored how green transition could be achieved through the medium of investment policy. Now, when we talk about investment policy, what is wrong with this investment policy, and how can investment policy be utilized as a medium for achieving the green transition? Now, to answer that question, we need to understand how did investment policy come about? So my lecture will go back into history, then take you to the present moment, then drag you back to the future to tell you how the future should look like based on my research. So it's a research-informed lecture based on what I've written. So the starting point, as I said, we have to go back into the past to understand how we ended up in this position. To do that, we need to understand what is time. What does it mean by going back into the past? It is very odd for a lawyer to put a physicist as a starting point. But indeed, what Einstein put forward through his theory of special relativity pretty much sums up the challenge that African governments are facing. Now, time, according to Einstein, can be described or can be compared to the flight of an arrow, bearing us from the past to the future. It's what Shakespeare referred to as the wheel of time. Now, in our daily lives, we divide time into three elements: the past, the present, and the future. The present, which basically refers to the reality we are living. The past means something which has slipped out of existence. And the future being something more unknown, a shadowy phenomenon or existence. According to Einstein's theory of special relativity, time is an illusion. So to Einstein, the past, the present, and the future are all operating simultaneously. Let me give you an innocuous example. If someone asks you what's happening on Mars currently, you wouldn't know. You wouldn't have a definite answer for two reasons. One, Earth and Mars are far apart. Number two, time, in other words, it takes 20 light minutes for light to cross over from Mars to reach Earth. So for someone an information does not travel faster than light. So for someone on Mars, for someone on Earth, if you ask them what's happening on Mars, there's no way they will know. Because that information, the 20 light minutes, will not have passed for them to know what's happening on Mars. For us, for Mars, that will be their past. For us, we shall be seeing the present of what's happening on Mars. So what I'm trying to argue is that the treaties, I'm talking about the investment treaties that African governments have signed. Those treaties are still caught in the past. We are living with them currently in the present, and we like to find them in the future. And my argument, or what I'm trying to push to do, is to get out of that amber zone. to start making reforms, to start seeing the light, in other words. For me, I've seen the light. I've been in that position where I've seen the light that has flown from Mars to Earth. But for them, they haven't seen it yet. So there's those 20 light minutes. There are 20 light minutes behind. So I'm pushing them to see how they can understand this. Now, what is the problem with these treaties? Why do they need to reform these investment treaties? First of all, these treaties are based on old templates. These are pre-colonial legacies. These treaties were signed in the 1960s. During the 1960s, we saw revolutions. We've seen pandemics. We've seen the Berlin Wall come down. We've seen so many things. We've even seen Donald Trump winning a second term. But ultimately, these treaties still remain, despite all those changes. So my work has focused on pushing reform in this area, ensuring that we reform these treaties to take into consideration a number of factors, but one of them is climate change or the environment. So as I said, we have to go back into the past to understand where did this fit. The starting point for me is Hugo Grotius. We have to go back to the 17th century. Hugo Grotius is renowned, for me, is the grandfather of international law. Hugo Grotius was a lawyer in the Dutch East India Company. He advocated for the freedom of the seas, which enabled the Dutch East India Company to gain the monopoly that it needed over the seas during that period. Before that, we had a Spanish jurist and philosopher, Francisco Victoria. Now, to Francisco, his arguments were foreigners, aliens, should be allowed to trade and travel freely. Now, to Francisco Victoria, essentially, what he was trying to argue is that resistance should be viewed as a violation. Resisting or stopping these individuals from trading should be seen as a violation of their self-proclaimed legal right. Much later on, in my view, we had the father of international law, Emmerich Vattel. And in his magnum opus, The Law of Nations, he spoke about nations, how nations should be able to trade freely. Now, his ideas were very critical to the development of doctrines in international law that favored colonial companies. During that period, in relation to these companies, they pursued their commercial interests as well as state ambitions, thereby blurring private and state interests. In addition to that, there were a number of issues with how investment was carried out during that period. One of them was in relation to dispute settlement, how disputes were settled. So during that period, British, Belgian, French judges often sat in local commercial courts to resolve disputes within colonies. And those disputes normally were handled and resolved in favor of colonial companies. Those companies were protected not only just by the courts, but also by the host state's law, but also the military strength of the colonial power. So that's problem number one. The second problem, at the end of the 19th century and early 20th century, we had the introduction of what we call concessions contracts. These concessions contracts contained what are called stabilization clauses. You see them today also in treaties. They exist. they contain what we call stabilization clauses. Now, those clauses refrained a state from using its legislative or administrative prerogative in a manner that may affect the profitability of the entity or the colonial entity. So that was issue number 2, the concessions contract. And also to add to that, those concessions contracts were often for a very long period of time. The Ashanti Goldfields concessions in Ghana, for example, which was signed in 1895 for 100 years, thereby prolonging the profitability of the colonial company. In addition to that, or to graduate from that, from concessions contract, we ended up having investment contracts. So from concessions contract moved into investment contracts. Those investment contracts had similar provisions to what we found in concessions contracts. Now, one of them, perhaps most troubling, was the use of contract-based arbitration as a means of resolving disputes. So in other words, within those contracts, within those agreements, there was a requirement to go to arbitration if there was a dispute. This created, as a result, we ended up having a system of rules being created within the international law regime to serve the interests of a few private individuals and companies. And today, this is the forerunner of what we call investor-state arbitration. One of the areas I've targeted my research towards reforming. So we have a dispute settlement mechanism that is not functioning. And the third problem that we had with these agreements at that time, there was no obligation on foreign investors. They were one-sided. These are colonial legacies. They were one-sided. There were no obligation on foreign investors. So things such as the environment, no one cared. They were never considered as part of the negotiations, because ultimately these were instruments that were supposed to be used to further the interests of the colonial powers. So where did that leave the environment? It left it in our hearts, more or less. And a famous scholar, Ali Muzrui, pretty much captures it in Africa's A Triple Heritage: Africanity, Christianity, and Islam. He talks about how the environment is deeply rooted in African culture and heritage. I use the example of the Kom people in Cameroon. For them, the environment, they have reserves, they have forests that have always been considered to be a key part of their culture. So they've been kept. They have not been, they've reserved those forests because they consider them a key element of their society, of their culture, of how they are as people. And also outside of Africa, I took an example from the Japanese. That is a Japanese wedding dress called the kimono. Sorry, excuse my Japanese, but I think it's kimono. Yes. As you can see, it features a flying crane, a bird, a crane, which is a demonstration of their deep reverence and respect for the environment and nature. So despite not having any international rules or laws at the time to protect the environment, and despite investment agreements at the time not protecting the environment, it was part of our culture. 1900s, they started to emerge a few international agreements aimed at protecting the environment. And I think the most important one of them all is the United States and Canada, what we call the Boundary Waters Treaty. The reason why it's so important, because it contained a provision, Article 4, that says water shall not be polluted. So they're talking about pollution, something that was unthinkable before that. Although it was outside of Africa, but it was a starting point. But we also had others that talked about marine life, wildlife, and so on, emerging during that period. But the environment, no one cared about it at that point. Investment was purely for commercial, profitable gain. Now, decolonization, the end of colonialism in Africa, was a turning point for a number of reasons. One, it meant that the former colonial powers could no longer rely on their treaties of capitulation. They could no longer rely on their old systems as a means of protecting investments. Number two, it meant that they left investments behind. Those investments needed to be protected. And without colonial treaties, they were unable to proceed on those grounds. They had to come up with a system of rules. It is a system of rules that, in my view, still caught in amber, that hasn't seen light yet, that I'm trying to challenge. Now, this system of rules is what we call bilateral investment treaties. We have treaties of friendship, commerce, and navigation, the ones that the US used to sign before that. But these are the ones which have lasted the longest and have been the most controversial. And bizarrely, very few people know about them. I've been to so many countries across Africa, and whenever you talk about bilateral investment treaties, most lawyers have never heard of them. Yet, in most cases, we find that their countries have been sued for billions pertaining to those treaties, for violation of those treaties. So the first ever bilateral investment treaty was signed between Germany and Pakistan in 1959. You have to remember that at the end of the Second World War, Europe was in ruins. Most of these colonial powers, or most of the European countries, they needed raw materials to rebuild Europe. So that's why there was a need to reach out to the other parts of the world to see how they can collaborate once again. But of course, there was resistance because most of those countries are just woken up. They just gained their political independence. So there was resistance towards European ideas. So investment treaties were seen as bilateral. It's between two countries. So they told them this is bilateral. We sit down, we agree, it's a contractual arrangement. But the only problem with this contractual arrangement, you have a superpower, a former colony, entering into an agreement with another country that may not be on the same size or same military or economic strength as it is. So you find that normally it's the developed and the developing entering these treaties. Only recently have we seen developing and developed enter these treaties. Initially, it was the newly independent countries signing treaties with the developed countries. So this is the first one ever. Germany and Pakistan, 1959. That treaty still exists today. That treaty is still in force today. Those are the protections it provides investment. It said neither party shall subject to discriminatory treatment. It provides one-sided treatment, one-sided protection. There are no obligations on foreign investors here. The obligations are only on the state. So the host state has obligations to protect the investor. You must ask yourself, okay, it's bilateral. So that means that if an investor moves from Pakistan and invests in Germany, they'll get the same protections. How many investors are moved from Pakistan? How many can afford to go and invest in Germany? Very few. I picked out Uganda as another example. Now, this is some of the treaties Uganda has signed. In 1960, Uganda gained independence in 1962. And in 1966, they entered their first bilateral investment treaty with Germany. It is still in force up to today. From 1966. So German investors in Uganda have protection based on this treaty that was concluded in 1966. What does it contain? The same standard protection, full protection and security, non-discrimination, fair and equitable treatment, and so on and so forth. All for the purposes of protecting the investor. I went into West Africa because Uganda was here. So I wanted to look at every part. West Africa, the Republic of Senegal. One with, as you can see, 1962. They entered one with Switzerland. And I picked out the one with the UK. And you can see the type of protections that are being offered. Promotion and protection of investment. Most favored nation provisions. Nothing that talks about the rights of the state. Nothing that talks about the environment. We're talking about climate change. This should be the starting point if we want to realize climate change goals. To North Africa, the Arab Republic of Egypt. Again, for them, because they've received a lot of cases, they started terminating some of their treaties. And most of them are still in force. With the UK, 1975, the world has moved on since 1975. That's the protection provided, one-sided, for the investor. There's no regard for the environment. There's no recognition that a state has the right to regulate in its interests. The Republic of Eswatini, so even the smallest, the former Swaziland. In 1990, and of course 1995 with the UK. If you look at the one with the UK, same protections. So you must be asking yourself, why is it the same stuff that we're seeing? Can't be after everything. Yes, this is supposed to be a bilateral agreement. Why is there no variation? Why are we seeing the same information from country after country? Simply because most of these countries had to follow a template that was handed down to them by the powers that be, the European powers. Because that template favored the interests of the colonial companies or their economic interests going forward. So where has that led us? Okay. Honesty. That's why I say that if you want to achieve climate change targets, this is one area we need to start from. Investment treaties. Now, let's look at cobalt mining I picked the DRC, the Democratic Republic of Congo. The DRC has half of the world's cobalt reserves. Now, cobalt generally is ubiquitous. From the phones you use today, the phones you are using, cobalt, it's running on cobalt. Car batteries, they use cobalt. Airline engines, cobalt. So it is ubiquitous. It's used almost for many things. You've used it. You're all using it. Who bears the brunt? It's the DRC. So in the DRC, millions of trees have been cut down to make way for cobalt mining. So it's an environmental genocide, more or less, that is happening in the DRC. And the Congo Basin is one of the few tropical rainforests that are left, but it's disappearing at quite an alarming rate, simply because of cobalt mining. So on top of destroying the environment, they can also sue if you try to impose or if you try to bring or to create new policies that affect their interests. There's a recent study there that I'm going to talk about shortly, but also I'm going to give you a few cases. Eco minerals versus Colombia. Let's start from South America. Eco minerals versus Colombia. 2021 case. The Colombian government passed a law, passed several laws basically, that ended up reducing the profitability of Eco minerals. Eco minerals was a company, or it is a company that is involved in extracting minerals, gold, silver, etc. The Colombian government passed several laws that reduced the profitability of the company. The company sued, saying that the Colombian government has breached its legitimate expectations. The company won. Let's go to Europe. RWE, a German company, versus the Netherlands. Now, the Netherlands passed a law in our policies to phase out the usage of coal by 2030, in line with this Paris Agreement requirements. So they passed a law to phase out the use of coal by 2030. A German company sued them, saying that one, they have not been given enough time to adjust. And number two, they have not been given an alternative. Now, what saved the Netherlands is that the Netherlands went to a court in Germany and argued that the case that was brought against them was in conflict with EU law, because that's an intra-European bilateral investment treaty. They said that it was in conflict with EU law. And the court agreed, based on Article 1032, subsection 2 of the German Code of Civil Procedure. The court agreed. Let's go to Africa. Coal mining versus the Republic of Kenya. Kenya passed several laws, and one in that treaty, it was based on the UK-Kenya Bilateral Investment Treaty, which was signed in 1999. Now, in that one, there was a requirement that for a valid investment, to be considered to be a valid investment, you have to have undergone an environmental assessment. The company needed to have done an environmental assessment for it to be considered a valid investment. Because the company did not undertake an environmental assessment, that's what saved the Republic of Kenya. So there are huge risks. In addition to destroying the environment, companies are bringing cases. Although they're not winning yet, they're winning, they're already winning only a small fraction. But the chances of these cases getting much more frequent has also been captured in a recent study that found that over 340 billion in legal claims would be expected very soon because of changes governments are putting in place to phase out oil, to phase out the use of fossil fuels. So that's the past. It looks very bleak. That's the past. We are moving on. So what's the present? The present is me, more or less. So when I started out, I looked at this scenario, I looked at the impact, I looked at these treaties. I was thinking, okay, then what can I do about this whole situation? So the starting point was to publish research. So this is some of those outputs that I had to produce. Some of the publications that came out of that research to find out how can we stop this? Where did it emanate from? What are the challenges it has created? I picked out one of them, which came out of a project that was funded by the Djibouti Chamber of Commerce. Now, in that project, we had to create an arbitration, a mediation center for the Horn of Africa. It was led by Jones Day and a few other institutions, including people like myself who are part of it. So I did research and I wrote a book on what I found through the IGAD region. That is the IGAD region, the Intergovernmental Authority on Development, Kenya, Ethiopia, and so on and so forth. All their treaties were all first generation. By first generation, what I mean, there were no obligations on protecting the environment. They were one-sided. There were no state protection. The whole state had no protection in all their treaties. So therefore, I made recommendations to these governments that you need to reform your laws, you need to reform your treaties to incorporate these modern innovations to be able to protect yourself better from foreign investors. But of course, this is a very politically sensitive area. Reason because investment and trade are key pillars for economic power. And of course, very few powerful countries would accept or would be willing, even if a country is sovereign, to enter into a bilateral investment treaty that does not really extend or serve their interests. In their view, in my opinion, they view the current system of bilateral investment treaties as serving their interests, but they're not serving the interests of the host states in the developing world. So what did I do about it? Remember the two issues that I mentioned. Issue number one is the dispute settlement mechanism. I said it was a contract-based dispute settlement mechanism, which is basically arbitration that they use currently. The first thing that I did, okay, so what can I do to change the dispute settlement mechanism? So one of the countries that has received the most cases in Africa is Egypt. So that was my starting point in Egypt, where I was able to present and voice my concerns on how the system operates, which led me to the United Nations with a few famous cases there. Now, my deliberations at the United Nations are captured by one of the General Assembly reports. So in there, I'm against the current state of play. And one of the recommendations that I made is the creation of an African investment court, a pan-African investment court. Let's move away from arbitration. A very controversial idea, indeed. But we can create a court system with judges instead of arbitrators, who are more likely to take into consideration African realities when making decisions. A court with an appeal and mechanism, not arbitration. So that was problem number one. I take it there. Currently, Ancitro Working Group number 3, United Nations, is one of the options they are considering, they are looking into, a multilateral court system. The second one was to develop modern treaties, create model investment treaties that could be used by African governments, and then for them to draft treaties that will help them to pull away from the old templates. I was part of a team, and of course, some of my research captures that. I think this was the North Carolina Journal of International Law. So some of my research captures those ideas. So we ended up drafting a model bilateral investment treaty for African states under the African Arbitration Academy. After that, part of my work has involved the African Union. Some of you must have heard of the African Continental Free Trade Area Agreement. So Africa came together. So let's create a Continental Free Trade Area Agreement. And part of my thanks today, I know it's premature, goes to Uganda's Minister of Trade, Francis Mwebase, because he drafted me into this project. So I was part of the Ugandan team that went negotiate the African Continental Free Trade Area Agreement and the investment protocol. So what did we have in there? The investment protocol. Your right to regulate. So now a state has a right to regulate. State can regulate in this national interest. Can put laws in place to stop investors from damaging the environment. Climate change is now featuring. We are moving away from the old templates. It's now one of the provisions, Article 26, that investors are required to adhere to provisions or to protect the environment, taking into consideration climate change. Environmental protection. Article 34. They must comply with principles, you must comply with environmental impact assessments, the same thing that we saw in Kenya. It's now a requirement. So from the United Nations, I went down to the African Union. I wouldn't say down because it's all multilateral. I wouldn't put the African Union down, but to the African Union. And from the African Union, I went back to the United Nations Economic Commission for Africa. This is quite recent Because once we had finished negotiating the African Continental Free Trade Area and the investment protocol, I was called by the United Nations Economic Commission for Africa to be the lead to assess whether the investment protocol is green enough, has enough green provisions in it. In the final report, which was published very recently, I made it clear there's not enough greenness in there. We need to do more to protect the environment. It was watered down. And of course, what the United Nations Commission for Africa will do, they'll go back to the African Union and tell them that when you're implementing the African Investment Protocol, the AfCFTA Investment Protocol, please ensure that you follow these particular measures that will ensure that there is green consideration in its implementation. Again, that's contributing towards achieving those climate goals. So I went from the African Union and the United Nations. I went down to the region, the East African Community. Now, for this East African Community, as we see us there, part of a team that negotiated the ESC investment policy and strategy, and of course, the development strategy. It was a 2-week initiative. We negotiated over a course of 2 weeks. I think you can see me right there in the middle. So that's the Ugandan delegation that negotiated those agreements. And in there, I wrestled. Because different countries had different agendas, different ideas. And one of the ideas that I put forward was that let's put obligations on these investors. A number of countries said no. I wouldn't mention the countries. But some of them said no. If we do that, investors are not going to come and invest. We need to attract as many investments as possible. And it's understandable. The ESC has some of the poorest countries in the world. South Sudan, Burundi, Rwanda, etc. But ultimately, because normally a voting system, I won. And what I got out of that is that. And I'm content with that. So one of the objectives is to achieve a balance of rights and obligations for investors and ESC partners states. That's better than nothing. At least I came out with that. That they have a balance of rights. So it's no longer one-sided. It shouldn't be just about investment attraction, investment promotion. The rights of the state should also be protected. At national level, I went down to the Republic of Uganda. Now, the Republic of Uganda's bilateral investment treaties are all old. Old bilateral investment treaties that don't really reflect the interests of the nation. So what I did through an organization called the Uganda Investment Authority, we negotiated that law. And obligations on registered investors are appearing now. As I said, this is the present moment, and I am that present moment. Recently, which was last month, I was involved in negotiating the COMESA investment area agreement. Now, this is a private document, but it was only sent to government officials. And because I'm negotiating for the government, I have access to it, but it's not a public document yet because it's still a draft version. So this is a draft version that we've come up with so far. So I see permission to ask whether use as part of this, and they said yes. So this is what we have in there now. This is how far we've gone. We have environmental protection and social impact assessments being required. So this is the evolution we've taken away from the one-sided 5-page bilateral investment treaties we used to see back in the days. And my argument is going back to what Einstein was telling us about his theory of relativity. My argument is that I saw this light before it crossed over. Remember, light. I saw that light, and I've tried to ensure that I show my fellow policymakers or Africans how and what should be done to reform in this area, especially to achieve in terms of achieving climate change goals. So what's coming up next? As you can see, my research has generally focused on policy. I'm a policymaker. I'm not really theoretical. You'll be able to find any theory from what I do. I'm normally focused on practical, policy-based initiatives. So one of them, I'm focusing on the Republic of South Sudan for two reasons. One, in order to create impact, you need to have, we know how REF works. You need to have written. Then, of course, from there, you have to create impact. Now, for South Sudan, they don't have an arbitration law, first and foremost. This is the youngest country in the world. They received their 4th case earlier this year in investment arbitration. So I'm trying to see how I can assist the Republic of South Sudan to develop their laws in such a manner that protects their national interests. I'm also trying to explore how the court system, because with the court system, although the UN is pushing different ideas, they are pushing different ideas on how the system can be reformed. They haven't concluded yet. And CITRO Working Group number 3, they are looking at different options. I'm hoping that actually the court system is one of the options. And of course, if it's not, I'll need to keep pushing further to ensure that that's embedded within the African context. But even if UNCITRO comes up with a court system, it won't be for Africa. It will be for the world. And I'll still continue to champion for the creation of a Pan-African system, a Pan-African court system, instead of using contract-based arbitration as the dispute resolution forum. Outside of academia, I also sensitize, especially starting from the grassroots. I am the chairperson of the Arbitration Fund for African Students. Now, this is a charity that was founded by Professor Emilia Onyema at SOAS, University of London. And she put me in charge as the chairperson of that charity. And our role, as you can see, we go all over the world, is to go and teach young people on dispute settlement mechanisms. We're trying to create capacity to empower them to understand how arbitration works, how ADR, alternative dispute resolution, works. That will enable them to go into the legal field and support us eventually in driving the sort of change they want to achieve. And I think, Jerry, my biggest contribution by far is not the treaties I've negotiated. It's not the publications that I've written. It is the people that people have empowered. Now, this picture was taken 5 or 6 years ago. Those were some of my PhD students. And I think that's what I'm most proud of. That they've been able to carry on my legacy. They've looked at various aspects of what I've been researching on, from investment courts to treaty provisions, different PhDs, touching on various aspects of my research. And of course, they've also gone on to pursue careers in institutions such as the Bank of England, Dr. Chijioke. We have Dr. Matthew Stubbins, who's the Director of Law at Canterbury, another former PhD student of mine. Our Masters in Law course director here, Dr. Obiajunwa, who's a senior lecturer, also my former PhD student. I can go on and on. So that's, for me, that's what I've given back. That's my legacy. That I've been able to empower so many and to see them succeed in various aspects of life. But of course, my thanks do not end there. I'm going to start off by thanking the Vice Chancellor, of course, the university leadership. Most especially, Professor Camille Omotesho. I had to learn the surname. Professor Camille Omotesho. For his ingenuity, support, everything. And from there, of course, I also have to thank the leaders within the law school, the professors, and of course, other staff members. But on a personal note, I have so many because my work involves a lot of policy work. So I needed hand-holding. I'm going to start by thanking most especially Professor Emilia Onyema. Professor Emilia, I'll call her my mentor. She's based at SOAS. We've worked and collaborated on so many things. Second of all, Uganda's Minister of Trade, Francis Mwelese, because he gave me the opportunity to negotiate so many of those agreements. And of course, Professor David Bachwinga. Now, I remember I was doing my first year of my PhD. I reached out to this professor. I wanted to write a book. And he said, no problem. He's a professor at Makerere University in Uganda, one of the leading, probably not the leading company lawyer there. He worked with me to get my first book out. And today, he remains a great friend. Professor Tom Motima, who was my head of school in 2 universities. Professor Steve Tong, we worked together at Canterbury to get right. Various things through. So, a great friend indeed. Professor Paul Idonoji, of course, Paul is one of the leading investment arbitrators in Nigeria. And above all, a great friend. And for so many reasons, I had to mention Paul Idonoji there. So there's so many of them to pick from, but I can go on and on. Baishu Pasani, she's Eunice, but of course Sue Jennings, she was a wonderful head of school. Dr. Jessica Booth, I think she's at Needs Beckett now. Now Jessica, when I started out, I think I was undergrad. She was 3rd year of undergrad, she joined. She was a very young lecturer. And I remember I got the highest grade in employment law. And she took me aside and said, Chrispas, this is very good academic writing. I think we can publish this. Like, really? 3rd year undergrad? I'm like, really? can publish, for only special people publish. We sat down, I produced something, and she published it. That was my first publication. Professor Dominic Wood, also actually mentioned that, and so many others. But last but not least, I've started by also thanking family members. Some of them are no longer here. That's why I had to. Some of them are no longer here. My family members, let me mention some names: Ruth, Betty, and Rose. And of course, Ruth, Betty, and Rose, and Ernest. They all bear the same name, a very complicated name called Kalyesubula. I don't know if you can pronounce it. But for being wonderful. And of course, the uncles as well for being there. Now, siblings must also worth a mention. Start by mentioning Moses, Gerard, and Ronald Cardew. Now, Ronald Cardew is a scholar, and I've written a few things with him. And of course, lastly, Isaac. And in addition to that, Elise and Florence, all of those in there. Now, my dedication for all this, my dedication goes to a wonderful woman. Now, she was my first teacher at a nursery school. Basically, she made me who I am. Because those early moments, the starting point is very, very important. If the foundation is wrong, everything will be wrong. She laid the foundation. So it goes to my grandmother, she's no longer here. Of course, I also have to, I included my grandfather there. Her name again is Mary. The surname is Kalyesubula again. So for everything, for what she stood for helping me to become what I am today. And I dedicate it to her. That wonderful individual.